Right. Welcome, everybody. We are going to get started. It's 10 a.m. Welcome to today's webinar. I am Amy Forbes, the training manager with the Northwest Mental Health Technology Transfer Center. And today's webinar is When Mental Health and Housing Subsidies Clash, presented by Elizabeth Powell and Casey Burton from our Tenant Law Center. I'm first going to tell you a little bit about the Mental Health Technology Transfer Center. We are a nationwide network supported by SAMHSA, and you can see by the pink circle there, the Northwest MHTTC covers Region 10, which includes Alaska, Idaho, Oregon, and Washington. The goals, or our goals at the Northwest MHTTC, are to support mental health related EBPs and best practices, heighten awareness, knowledge, and skills of the mental health workforce, foster alliances and address diversity of training needs, and share publicly available training and technical assistance. Our areas of focus include evidence-based practices for psychosis, such as CBTP and ACT, or assertive community treatment. We also do many other trainings and webinars, which you can see on our website. On there, we host live and recorded webinars. We have virtual learning communities, online self-paced courses through Healthy Knowledge. We also have a weekly newsletter, which if you have not already, please subscribe to it. It is great. We offer resource library and also a podcast called Putting It Together. Just a little bit about today's webinar and kind of housekeeping. At the end of the webinar recording, you'll be sent a link to the recording of the webinar slides and your certificate of attendance. Also, we have two boxes at the bottom of your screen. One will be chat and one will be Q&A. So for the chat, we would like you to use it for any technical issues that you're having. If you have or need help from a staff member, you want to share general comments, greetings, or observations with everybody. Please remember to keep all comments respectful and directed towards this training and its materials. Our staff will monitor the chat and will take necessary measures to make sure we have a safe and collaborative learning environment. Please use the Q&A box throughout the presentation at any time if you have any questions directed or that you would like to have the presenters address live. I will be monitoring the Q&A box, and we're going to answer as many questions as possible at the end of the presentation. And everybody's going to receive an evaluation. Please do fill it out. It really helps us know what we're doing well, know what we can be doing better, and any trainings that we can offer people in the future. We are required by SAMHSA to have the survey, but they do not have any position on the content of the survey or the content of our presentations. Again, this is just how you can connect with us on our website, sign up for the newsletter. Oh, sorry. Okay. I'm just going to stop sharing and I'm just going to go through the slides. You can see on our website too that we do have a couple upcoming webinars. I'm going to just talk about those. That is Strengthening Clinical Supervision in Mental Health Care. It's coming up March 29th. So look out for that. And then we also have on Wednesday, April 10th, Conscious Leadership and Advocacy Through a Polyvagal Lens. So please look out for those. Check out our website. And now I would like to present today's speakers, Elizabeth Powell and Casey Burton from the Tenant Law Center. Welcome, and thank you for being here.
Thank you for having us, and thank you to everybody who's here today.
There, I've unmuted myself, and I'm happy to be here as well. I hope that this can be a helpful presentation. Casey and I are both Washington attorneys, and so the legal advice that we can give you, there's some federal elements to it, but there's also Washington state specific laws, which could be very different from where you are. I have learned over the years that landlord-tenant laws in different states vary tremendously. We're a pretty procedurally friendly state for tenants. At the same time, the bottom line is that the property owner gets to do what they want to do. So anyway, do you want to talk about what we do at Tenant Law Center?
Yeah, I'm not seeing our slides, Amy. Perhaps, oh, do I need to press share screen again? Let's see. Oh, there we go.
Yes, share screen. Yeah.
Okay, got it that time. Hi, so I'm Casey Burton, Senior Staff Attorney at the Tenant Law Center, and we do eviction prevention services in King County. And basically, we try to keep folks out of eviction court. So we try to help folks preserve their housing subsidies, negotiate resolutions with landlords. We evaluate documents served on tenants to determine whether or not they're valid, provide advice. And Elizabeth is one of our amazing staff attorneys.
I am, and we deal with people that are in different sorts of public housing. And so here at least, that can be an administrative procedure. Sometimes it turns into court, but we have some federal rules that we can rely on to make sure that tenants get a fair shake in that process.
So before we jump in, so y'all know where we're headed. First, we're going to talk about what exactly a housing subsidy is. And there are a lot of different kinds of housing subsidies. So we're going to talk about some of the types of subsidies that exist. We're also going to talk about how behavioral health issues can impact a housing subsidy, what those potential conflicts are. And then we'll jump into how to handle those conflicts, managing to ensure that the client still receives the help that they need and protects their housing. We'll talk a little bit about resources and take as many questions as we can, the time that we've got. So what exactly is a housing subsidy? A housing subsidy is essentially a regular payment by an agency or a government entity that covers some or all of a tenant's rent. And it can be a fixed amount. It can be dependent on a tenant's income. It can depend on how many people are in the household. There are a lot of ways that it can be constructed, but basically it's a regular payment to help cover rent. And there are a bunch of different kinds. So at the federal level, for example, you've got the housing choice voucher, which is more commonly referred to as Section 8. There are also tax credit units. There are project-based subsidies. You live in a specific building owned by a housing authority, and that might be subsidized. There are also a lot of state level programs too. So for example, in Washington, we have HEN, which is Housing and Essential Needs. And that's something where if you meet the qualifications, then you can get $1,000 a month every month for your rent, so long as you're eligible. There are also temporary subsidies, such as rapid rehousing, to help folks get housed and maintain that stability for a while. And I mean, there are just countless iterations of different kinds of subsidies, but hopefully some of those sound familiar to folks. And one thing we want to note is, first of all, a housing subsidy is a property right. And that property right is part of a triangle relationship. So as you can see, we've got the relationship between the landlord and the tenant, and everybody kind of knows about that one. But if you've got a housing subsidy, there's also a relationship between the tenant and the subsidy provider. The agreement essentially sets out the qualifications and requirements, the things that the tenant has to do to continue receiving that subsidy. And then there's also the relationship between the landlord and the subsidy provider, Are you maintaining the unit in an adequate condition and completing repairs so that we can continue making these payments? You have to agree to accept these payments. And, sometimes landlords push back against that, and there are ways to handle that, but that's another presentation. And there are a lot of ways that behavioral health issues can impact a housing subsidy. So for example, maybe there is a client who is acting quote unquote strangely, and the other tenants are kind of looking at them like, oh, this person's really weird. I'm not comfortable with them being here. And that can make the landlord try to either evict them, or the behavior could jeopardize the subsidy, even especially if maybe there is an issue where the client is triggered and they become aggressive. But there are other ways too. So maybe the client has a mental health condition that impacts their ability to do things on time. So making payments, or fulfilling other obligations under the lease or program, and staying on top of the timelines that have been set out. Another way would be hoarding behavior. So the landlord gets upset because the tenant is hoarding, and they say, well, I want you out because you've destroyed my unit. And the housing subsidy provider says, well, if you're going to get kicked out, then we're taking away your subsidy. So I'm sure all of you can think of a lot of other ways too, but ultimately it is important to know that there can be a connection between these two and it can be impacted. So now we'll hop on over to Elizabeth, who's talking about federal subsidies and how to respond to any behavioral health issues associated with that or having an impact on it.
Okay, so when housing and urban development is involved in the transfer of that subsidy to a tenant, typically the tenant is going to have a caseworker, and the caseworker is going to be able to help with resolving some of this stuff. So there's different ways that we do this. I'm thinking of one particularly. We got a referral from a different agency here in Seattle that they couldn't help this lady. They felt they had a conflict. And the day I got the referral was the day after her appeal deadline had run. And so I did what I call one of my Hail Mary emails to the people in charge of the housing authority and said, I cannot turn back time. Can we please set this for hearing? And the response was sure. So and then they gave her back her subsidy, thank goodness. Part of that was her doing a really good job advocating for herself during that hearing. So I prefer to start with informal conferences. They'll tell you that they want it to be a grievance. And it's a distinction that kind of doesn't have a difference, but a grievance makes the housing authority think that the tenant is upset about something. And, maybe that's the way they want to approach it. I personally think that approaching it from a non-adversarial approach is going to make it easier in the long run to reach a level of satisfaction between both parties. And sometimes that requires having a whispered conversation with my client behind the scenes about what they need to do or not do. And I know Casey has had at least one case I can think of recently that really did involve hoarding. And those are really tough cases because the person that has that disability feels like they're being attacked. And of course, that's not what anybody's trying to do. And all I can say is I wish all the best, and that early intervention and constant intervention, setting up meetings, checking in with the client, making sure that things are not getting out of control, because
An ounce of prevention is worth a pound of cure.
Oh yeah, absolutely. In that kind of a situation. So that seems to help. But that informal conference can be a Zoom meeting with the subsidy provider, the client, and counsel. And then we just sit down and talk about what the problem is. And the other
There's
thing,
real quick. I'm going to jump on in, Elizabeth, because I think we need to define informal conference for folks.
Yeah.
So let's say your client gets a notice to comply or vacate.
Right.
Immediately they have the right, unless it's something really intense, there are limited exceptions, then they have the right to request an informal conference to discuss the matter with the housing authority, the local housing authority. And if that doesn't work out, then you can move on to a grievance hearing. Do you want to talk about that process, Elizabeth?
Sure. The informal conference really is just typically a Zoom meeting. I've actually gone to them in person as well, just sitting down with the caseworker at the housing authority and my client. And all right, this is what we need to talk about, and just getting everybody on the same page. And if the housing authority says, yeah, no, what you're asking for is not reasonable, we're not going to do that, then yeah, what you would be grieving is that denial of services to the client. And it's so fact specific, that accommodating behavioral issues can be extremely difficult if you've got a client who maybe doesn't have a lot of insight about what they're doing and why other people might be. Um, yeah. So I'll get to your question in a minute, Mr. Hasiak. Um, Jack. But you try. And the other thing you're doing in there is you're laying down a paper trail so that somebody else can come along, see what happened, and then take it from there. Grievance is a little bit more formal. Typically, there is a hearing officer who may or may not work for the housing authority. Sometimes they're independent, sometimes they're not. And the housing authority typically doesn't send a lawyer to these. And I find that really interesting because I think that they could do a better job if they did, but they don't. So I'm not objecting to it. But the other thing, and I don't know if this is true in other states, but here in Washington, HUD, in its infinite wisdom, has decided that Washington's show cause proceeding that's the legal proceeding for evicting somebody, is not as protective as the HUD policies. So if the housing authority doesn't bother to go through the informal conference grievance process, then they don't get to get their writ at a show cause hearing. They have to actually take it to trial. And so that's just another thing that we can hold in our back pockets.
And show
Whenever,
cause hearing, I'm going to jump back in because I think we get with more lawyers, we know what all these terms mean.
oh yeah, okay, all right.
So a show cause hearing, when in Washington, if you want to evict somebody, you file an unlawful detainer action because you are unlawfully detaining the property is the theory behind the terminology. And usually what happens next is a show cause hearing to determine who's going to get to hold on to the property. And usually it ends after the show cause hearing just because once the writ of restitution, the writ restoring possession to the landlord is issued, the case kind of fizzles out. But sometimes they do go to trial. And there are certain restrictions where if HUD doesn't follow certain requirements, they cannot get that court order saying you get the property back.
Right.
You're seeing all the questions, right?
I am seeing the
We are going to
questions.
handle the questions at the end. And just as a quick, though I will do a quick aside,
Okay,
Aiden,
yeah.
I recommend you check out the Northwest Hoarding Coalition. It's for service providers.
Oh yeah. And I'm sure that there's other agencies that do that around the country. And it can definitely be an issue in housing because that's where it happens. So completely worth it. The other thing to remember too is that if if someone, for example, has not paid the rent, it's pretty cut and dried what's going on. And so if someone has done something inappropriate, that's much more factually dependent. There might be something to be argued about it. There's also the whole, my client needs reasonable accommodation. And so that is the kind of discussion that a judge is going to want to flesh out, take to trial. And we say trial, like it's 3 weeks or something. It's usually about 4 hours. They're very quick and dirty, but that client has a chance to say what they want to say to a court. And then of course, you can appeal it. Anyway, so the whole having backup as the formal judicial process that is going to happen before your client actually has to pack up and leave. And that can give clients time to see if they can make some changes in their behavior and how they're managing things. So that's an advantage to the client. So, okay, what are we looking at now? Thank you.
Sorry.
That's all right.
Trying to find the Northwest Hoarding Coalition link.
Ah, okay. Okay. Do you want to change slides?
Yes.
Okay.
So now we're going to turn over to more state level programs. So for example, HEN, which is administered through our Department of Commerce, and that sort of filters down through different agencies and organizations who actually fully do the on the ground administering of the program. They register people for it. They make sure they maintain eligibility and everything like that. Like HEN and rapid rehousing that I was talking about. So why don't you talk a little bit about those processes? Elizabeth?
Yes.
Yes.
I'm listening to you saying that you're going to talk about something. I
No.
just want to point out what HEN stands for. It's housing and essential needs. And it's a thing here in Washington, and that may not be the same all over the country. I'm not sure. And our state provides subsidies for people in terms of tax abatement for owners when they are willing to offer people a non-market based tenancy. And so that is very typical for people who are either older than 55 or older than 62. And so that is one totally permissible kind of discrimination that they can say, nope, you cannot live here unless you are X number of years old. So, and Casey pointed out that it'd be handy to know what case managers can do when you've got a client who's got an issue and, oh my gosh, you got to do something. Number one is to know that. And so, we generally come into that process hopefully pretty early on, because the earlier we get involved, the better we can do in terms of results. And so if your client gets a notice that says you need to comply or vacate within 10 days or 30 days or whatever, that is a really good time to reach out to legal counsel and say, what do I do? How do I help? And we're going to walk through that notice really carefully and see what it's alleging. Typically what it says is your lease says that you have to do A, B, and C. And then if it's going to be an official effective notice, it's going to say, on this date at this time, I saw you, I don't know, not pick up after your dog, something like that, right? And that the person has 10 days in which to correct that activity. There's also a 3-day notice that says what you are doing is so completely intolerable that we're not going to give you a choice. You just have to get out of here.
And these
And
are Washington notices, just as a heads up.
yeah,
Like the statute lays out, Washington now has just cause evictions. So there's a list of reasons, and those are the only reasons you can evict somebody anymore.
right. And so, and there's a whole bunch of procedural stuff that either the subsidy provider or the landlord have to go through. And one of them is that if the landlord's going to give a tenant a notice, they also need to give it to the subsidy provider. And for reasons that escape me, they sometimes just miss that. And so the subsidy provider has no idea this is going on. And the provider, chances are, is your best ally in keeping that client's tenancy, because that's what they do for a living. They want to keep people housed. So as opposed to landlords who may have a slightly different take on it. Washington State also has local kind of private providers of housing. We have one called the Low Income Housing Institute, have a couple is okay, and this is a good question. Do they get penalized for not sending the housing authority a copy of that notice? Well, they can't proceed until the housing authority knows what's going on, because the whole point of a housing authority is that somebody is sending that landlord money every month. And if they don't tell the landlord, this client is a problem, we need this person not to live here anymore, then the provider could be continuing to pay rent for somebody who doesn't live there anymore. So, yeah, you want to make sure that they know about it.
And that's
So
more associated with a federal subsidy, where if they have a voucher or something like that, they cannot proceed without providing that notice to the housing authority or the case manager at the housing authority. It's a little bit different for local ones, and that's going to depend on what each program provides and what their requirements are. I know, for example, a lot of the HEN case managers that we have at Catholic Community Services, which is where the Tenant Law Center is housed, they often get notices, but sometimes they have no idea either. So the sooner you can get your client to communicate to you that there is an issue, that's also always helpful.
yeah. So sometimes with a notice to comply or vacate, sometimes it can be very helpful to respond and say, well, actually, that wasn't me. I didn't do that. Or some sort of a explanation to the landlord. And it could be as simple as, I'm sorry, that will never happen again. And that can be enough to just derail the whole thing. And that can be to everybody's advantage, as opposed to boxing a client into a corner where they can't, you know, they're risking being homeless. And of course, that can be terrifying for anybody, let alone if you had a mental health condition that made your life more difficult. So we try really hard not to let it get to that point. So, yeah,
You want to hop to the next one?
sure.
So this is one thing I'm always harping on, put it in writing. And Elizabeth's the same way. If
Yeah,
you talk to the landlord on the phone and they say all sorts of nice things, send an email afterwards and say, this is my understanding of our conversation. Correct me if I'm wrong. And even if they do not respond, you now have something in writing from about the same time as the conversation that can probably be used as evidence in court. And it's really important because it's a lot easier to use a contemporaneous recorded recollection, that's a legal term, which is the email, to say, look, this was from the time of the conversation and you didn't respond to this message saying they misunderstood. So we're going to kind of lean towards this versus two people showing up and giving verbal testimony that say two completely different things.
right. And I talk to clients about that a lot, that, well, I'm going to say in Washington, that the rule was written in 1973, and it says when the tenant has a problem or tenants responding to a notice, the tenant shall advise the landlord in writing. And in 1973, fax machines were not really available. I know they existed in the government, but when they say writing, they literally mean a piece of paper. And so I agree that if what you're doing is communicating with a manager or the housing authority, something, that email's fine because you can print it. You can bring it with you if you need to. But the idea of saying, here's what I said, here's what you said, I got the impression that you agreed with me about blah, blah, blah. If I'm getting anything wrong, let me know. XOXOU. That can go a million miles towards convincing a judge what actually happened. And then the idea of getting program information and paperwork, all this stuff's going to be on paper. And the hardest thing to get a hold of is ledgers. I have no idea why they're so difficult, but a email to a property manager saying, hello, could I please see the ledger for this person's account from date to date? And typically they'll send it to you because they're saying, well, this person did blah, blah, blah. Okay, well, let's look at if that's something for which they can be, evicted. In Washington, their non-possessory charges cannot be the basis for an eviction action. But boy, howdy, do I see ledgers with late fees, or my personal favorite, attorney fees charged by the landlord before a judge has ever seen it. And then they run into court going, they owe us money. No, they don't. That's not how this works. So anyway, but that's that's not behavioral necessarily. But your client should have a copy of their rental agreement, and the housing authority will have a copy of the agreement that they use between themselves and the landlord. That can be really handy to see too, because it spells out the landlord's responsibilities. So you might want to, look for that. And then you kind of arming. No, go ahead.
I keep jumping in, please finish.
Okay. All right. But that also enables counsel to have a much clearer picture of what in the world is going on. So that's a huge help. And then next one is reasonable accommodation. Fair housing laws are national. They're not just Washington State. In Washington State, okay, this is funny. Landlord-tenant laws are found at Title 59 of the RLTA, which is, the RCW's Revised Code of Washington. All the laws about reasonable accommodation are found in Title 49, which is called labor. I, for one, would not know to go look in that section to find the Washington State law against discrimination, and yet there it is. And it has absolutely plain, simple language that says, thou shalt not discriminate. And then it's got a whole bunch of different, basis for discrimination in any way, in any sort of real estate transaction. And it's really helpful. So you can always write to the landlord or the housing authority and say, I'm so sorry, I have such a head cold right now, and say, my client needs reasonable accommodation. And you don't have to go into details. You can be a little vague. And what they will generally do is respond with a form that they want the patient or the client's doctor to fill out, going into a little bit more detail. Because of HIPAA, they're not going to go into a lot of detail. But the doctor, the medical provider can certainly say, yep, I've been treating this person for X amount of time, and this person needs this accommodation in order to be able to enjoy their housing opportunity. And that's code for don't discriminate. And it can be really helpful. And so there's just all these conditions out there in the world that might make somebody else feel like they were off put by somebody, but they're perfectly reasonable from the client standpoint. And so a caseworker, you guys, can help express to a client that if, they're getting a lot of complaints about noise disturbances at 2 o'clock in the morning, that maybe they want to think really hard about practicing their trombone during the day, right? And see if that helps, because chances are it will. So, and then how do you show that it won't happen again? You show not tell. It doesn't happen again, right? And so when it does happen again, then you can start the whole thing all over. It is frustrating, but the whole idea, as we see it as lawyers, is that you guys are boots on the ground in dealing with the clients. And so your interactions on a weekly basis are probably going to make all the difference in the world in that person's ability to cope and know what they need to do to look after themselves. And they really can. I mean, that's been my experience anyway, but it takes a certain amount of management.
Well, the nice thing about getting program information too, just to jump back a little bit, is it'll tell you what your options are in helping the client. If it's HUD-based subsidy, then you've got information on, okay, you want to request an informal conference? Great, this is what you need to do. This is who you need to contact, because usually the letter will have, if you want an informal conference, contact so-and-so before such and such date.
Right.
Or, maybe the client doesn't have any options just due to the nature of the program where the client's receiving the subsidy, and you have to figure out an alternative, and that can be the reasonable accommodation. And I think the reason at least that I threw in the how can you show the incident in question won't happen again is because if it's a pretty severe situation where somebody feels threatened, like another tenant or a property manager, they're going to want to know that this isn't going to be, there's not somebody dangerous on the property. That, okay, well, we're changing treatment to address X, Y, and Z, and that's going to show, okay, we have a plan so that we're set. This isn't going to be an issue ever again. And they will probably request verification. But one thing to know is that they are not entitled to any information about the nature or severity of the disability. So they can't ask for a diagnosis. They have no right to do that.
Yeah.
And you have to show that there's a nexus, a connection between the diagnosis and the behavior that caused the problem and the requested accommodation. So because of such and such diagnosis, my client engaged in A behavior and resulted in B outcome. But because we're doing this, this reasonable accommodation will address A so that we don't have to worry about B coming up again. And it can be frustrating because sometimes, the folks that you're communicating with are resistant to listening to that. And that's when I would encourage you to reach out for legal resources and legal help. In Washington, every county has a housing justice project because, well, we just do, but also now due to the right to counsel, they have staffed up a lot of those housing justice projects. And if they can provide you with eviction prevention assistance, then, go for it, send the client on over. And Elizabeth, I really appreciated that you pointed out that you as mental health and behavioral health providers can help the client understand what exactly is happening, why it's happening, and what needs to change and what their options are. I mean, you also have the opportunity to really turn this into a chance for them to engage in self-advocacy, of empowerment of, okay, you can request this informal conference. And maybe they do need help, and that's okay. Everybody needs help sometimes. But at the same time, helping them understand that they do have options and they're not powerless and that they can deal with this and make it through. All right, so we'll jump over to resources. So for Washington, we are, of course, familiar with Washington State resources, being Washington attorneys. And there are two really important resources, the Fair Housing Center of Washington and the Washington State Human Rights Commission. And you can report discrimination to both of those agencies and they can give you information. Sometimes they can offer assistance. That link right there, and these slides will be sent out, provide you with an overview of different types of subsidies because there are so many. And that HUD fact sheet does talk about the implications of mental health on housing for HUD tenants. Did you want to throw some additional resources in there, Elizabeth?
No, the other thing I would recommend, depending on where you're located, is to see whether or not your city or county has a Office of Civil Rights. For example, Seattle does. And Tacoma calls theirs something different. Office of Human Rights and Equity, I think. But anyway, a lot of cities have that. And so that can be an avenue to be expressing that you believe that there's something improper going on with the way your client's being treated. And those are good places to start. Are we going to talk at all about emotional support or service animals?
Well, we are doing a whole presentation on that later. I don't
Oh,
remember
that's a
exactly what
different
month,
movie.
but if you want to do a quick
Just
overview,
really
I don't
quick.
see why that would be bad.
Okay, this service animals under the Americans with Disabilities Act are an animal that has been trained to provide a specific service for a person. And so we're all familiar with guide dogs for somebody who's blind. There are also deaf and hearing dogs that can accommodate somebody who can't hear. There are dogs that have been trained to detect seizures and bring medication, do all kinds of amazing things. And so doesn't require some kind of licensure. That's not important. It's that the dog has been fairly carefully trained to provide some kind of a service for their person. And yeah, we don't allow landlords or anybody else to discriminate against people who need to have a service animal. And then we have the category called emotional support animals. And an emotional support animal can make all the difference in the world for a person with behavioral deficits because they have to reach out themselves and take care of an animal, and that can be really good. And so here in Washington, you can write to the, you don't have to, but you can write to the landlord and say, my client requires reasonable accommodation. They're going to have an ESA. So that's really the end of the story. That the landlord doesn't get to have a fit. They're not pets. They don't get to charge pet rent. They don't get to charge massive deposits. They just have to accept the fact that there's going to be an animal in the household. And of course, this upsets landlords because God forbid they should have to deal with an animal in their unit if that's not what they want to do. I have never heard of a genuine service animal misbehaving to an extent where they were a menace to anyone. They're really focused on their person. The only thing they care about is watching that person, making sure that they're getting what they need. And an ESA doesn't require anything like that level of training. It's just not there. And so ESAs have been known to misbehave. And a landlord can say, all right, I'm done with this because this animal is being a menace to other people in the building. That would be a really good reason to do an informal conference and to discuss with the landlord what the tenant's going to do to make sure that the dog is not disrupting the rest of the households in the building. So anyway, I just think it's important to recognize service animals, that's national. Emotional support animals, you want to check and see what your state has to say about it. So, but it's worth it to know about, and it's not a basis to, issue notices and say, get rid of that darn dog. No, they don't have to. So, anyway, a lot of clients will also take what their landlord tells them as just gospel, and they have no idea that their landlord's objective is just to get the rent paid, to have life be quiet at the building. And so landlords will say things like, well, you have to leave this week. No, they don't have to leave this week. There's a process. It's not just that the landlord gets to say, be gone, and that person has to leave. And so I feel like a lot of what I do is is realign clients' expectations about what landlords can and can't do and what courts or administrative bodies will or will not do. Because a lot of people are used to looking up to their landlord as an authority. If their landlord was an authority, they wouldn't be the landlord. They'd be, doing
Wow.
law in the place. Right. And so typically they don't know, and they will tell clients or tenants things that are to the landlord's benefit, but frequently have absolutely nothing to do with the actual law. So a lot of times I have dealt with clients who are practically in crisis because they think they have to leave within the week and the landlord's going to show up with the police officers. No, that's not how it's going to work. And you have time. You can take your time, figure out what you want to do, make some choices, ask for a hearing. You have time to consider what you want to do, not to rush. And for a lot of people, that are having behavioral crisis, when you add a time pressure on top of it, makes it that much worse for them. And I don't wish that on anybody. So that is one of those things that I think can help people. But, for people here in Washington State, yeah, we've got offices. Well, Northwest Justice Project has offices in pretty much every county, not all of them, but pretty close. And so if you have a client that gets a notice, you can absolutely reach out to Northwest Justice and say, I think this person might need help, and they'll pay attention to you. And they can do a consult, and they can explain to the client that whatever emergency thing that the client thinks is going on actually doesn't happen like that. And so I think that okay, and the idea that you can't reach out to okay, let me rephrase that. Lawyers aren't allowed to cold call people, but anybody can call Northwest Justice. And a phone call might be, hey, my name is so-and-so. I'm a case manager for this person. I'm going to have them call you because they're having a tenancy issue. And then there's a little bit of, okay, now we know what might be coming in. And then hopefully that client can pick up the phone and call them. And I realize it's really frustrating to try and get through sometimes. But it's really worthwhile because then you'll get actual information instead of the landlord's theory about the way things should go.
And
So,
another great resource is actually
oh yeah,
WashingtonLawHelp.com.
yeah,
They have so many guides on so many different areas of law, but particularly relevant to our presentation, tenants' rights.
yeah,
So they've got guides on just about everything you can think of as far as tenants' rights. I do see that somebody said, where can I find the Washington State Just Cause list? Well, it's under RCW 59-18-650. But if you want it in normal human language instead of law language, Washington Law Help has a great just cause guide.
yeah,
And they put everything in, regular people terms, not just legalese, because that's not particularly accessible to everybody.
right. So,
Okay. Do you want to jump into questions? Because I see we already have a bunch.
okay. Shall we?
So
Of
want to just go back and forth?
Can I just jump in really quick?
Yeah,
Sorry.
absolutely.
course.
I'll show myself. This is Amy. So the first question, I was going to type something, but I wanted everybody to hear it. So somebody had asked, going back to landlords who give pushback, they're the hardest to deal with. It would be great if you actually would do a webinar around strategies for dealing with those. And just to let everybody know, Casey and Elizabeth are going to be back on 6/20 to discuss just that. So please check out our website, register for that webinar. It's called Landlord Behavior and Behavioral Health, Dealing with Difficult Landlords. So just
Yeah,
to let everybody know.
thank you. Yeah, and you are remembering all the dates offhand, which I should have beforehand. And another thing to know about that pushback is, one, obviously document that they are ignoring you or not listening. If you need to, provide citations to the law. And sometimes they're going to push back, and there might not be anything you can do to make them change their behavior, which is so frustrating, especially for the client who's dealing with the stress of like, where I live is at jeopardy, and this landlord won't listen to the law. Ultimately, if the landlord refuses to back down on a particular issue and the client ends up in court, at least in Washington, if they qualify, then they will have an attorney to make those arguments for them, to show all of the good faith efforts that the tenant made to work with the landlord, because, some of them just won't bend, and that's frustrating.
My theory is that none of us are the landlord whisperer. They have a lawyer. They can go ask their lawyer questions. And it's not my policy to hand out advice to landlords. Let them figure it out. They've got the money. So anyway, I don't typically write crabby letters to landlords saying, you're doing it all wrong. You need to do something different. I'm just gonna wait, see them in court, and explain why their case should be dismissed because they screwed up something really important. That's me. Casey handles it a little differently.
A little bit. And I think that, that would be an important role for a behavioral health providers to talk to the client about coping with the stress and anxiety associated with waiting for the other shoe to drop in a way.
Yeah.
Because, you don't want to get in a landlord's way if they're making a mistake. And you also don't want to tell them, oh, hey, this notice you issued is wrong for X, Y, and Z reasons, and this is what you need to do to fix it, because then you're just telling them how to give your client a correct notice. When Elizabeth's right, if you can afford more housing than you can live in, then you probably have the resources to figure out what the law is. And you also, there are a lot of online resources for landlords too.
Yeah, there are.
Really quick too, I'm going to jump down to the bottom just because it pertains to what we're talking about. Are landlords and property managers the same thing? Someone's asking.
Sometimes. It depends. Oh, that's such a lawyer answer. A landlord is technically the person who owns the property, and the property manager might be somebody totally different that the landlord has hired to manage it, to manage that property that they own because they don't want to deal with it. So they're paying somebody else to.
And I just use them interchangeably.
Yeah.
Yeah, if they own it but don't manage it, all right, that's different. But typically there is a frontline person that the tenant's going to interface with, and that can be the landlord, that can be an agent, kind of really doesn't matter. I want to answer that question about subsidies for individuals with a criminal record, registered
Read that
sex.
out loud. Which one is that?
Yeah.
What's
Yeah.
that?
Um,
Are there housing subsidies for individuals with criminal records or registered sex offenders or clients in recovery?
yes. So, here they're called, well, they can be called transitional housing, and they are available to persons who are coming out of a stint in prison, persons who are sex offenders, persons who are in recovery. All those things are put people in a position where they can't pay market rates for housing. So the provider in Washington state must be a not-for-profit organization of some kind. They tend to veer towards religious organizations, and they also have some exciting ideas about how many people can be in bunk beds in a 3-bedroom house. But the rent would be something that would be roughly a third of what that person's income is. So maybe $300 a month, maybe a little bit more. There's also an organization here in Washington called Oxford House, and I think they're more geared for people in recovery. But that's exactly what they do. And they are nonetheless subject to the Residential Landlord-Tenant Act. They just have special rules about notice, because for people in recovery, instead of getting a 3-day notice to get out, a 1-day notice saying, I need you to come back with a clean drug test within 24 hours is a perfectly reasonable ask. And so, but that is the predicate to an actual formal eviction. But a lot of these people in that situation have no idea that they're actually covered by the Residential Landlord-Tenant Act. So if the landlord says you need to leave now, they evict themselves. It's terrible.
Yeah, we generally tell folks to stay put until we have the opportunity to really evaluate what their options are, go through their paperwork, and talk next steps, because a lot of folks, we say self-evict and they might not need to. I don't know of any federal subsidies for those specific populations, so I would definitely recommend looking more at the local level and seeing what your state and county and city have, seeing what the options are there.
Yeah.
What about when the tenant is at risk of losing their voucher because they cannot pass inspections due to hoarding? We give them reasonable accommodations and reasonable time, but it keeps happening every year. That seems almost, that's tough because the law can't really keep people from doing stuff. It can respond. And in this instance, it seems like maybe the underlying issue requiring treatment would have to be addressed versus it being a legal issue. What do you think, Elizabeth?
I agree that if what a person needs is a therapeutic process to consider why they're hoarding and that might get them through it. I know it's really difficult. I have dealt with a couple of people in that position. And so I go back to the idea that if you've got a client that is demonstrating a propensity to want to hoard, that probably the most effective thing you can do is to get eyes on the situation once a week, once a month, something, so that you have a sense of what things look like, because the client's ability to self-report accurately can be somewhat incorrect. So,
I think these next two kind of go. So it's a non-possessory charge. And did you say that you can't use late fees towards a non-payment of rent notice? So non-possessory charge would be like a late fee, or some other miscellaneous fee. You can't take somebody to court for a late fee. And
in
so
Washington,
if they give, yeah, in Washington, thank you for that clarification, because it's in the statute. You can't get rid of somebody because they didn't pay a late fee. That's something that the landlord could potentially take out of the deposit or go after the tenant for later. Maybe after they move out, they can put that debt on their record, but they cannot give a pay or vacate just for fees.
well, and they can't give a pay or vacate for rent and for late fees. That's not going to work.
Especially because the court, let's say you end up in court in an unlawful detainer action, the statute actually limits how much they can even collect in late fees if there are any owing. The cap is $75, I believe, right, Elizabeth?
Correct.
Does SUD count for reasonable accommodation in Washington? I don't know what SUD stands for,
Yeah.
SUD. Does anybody?
Morgan, can you tell us what SUD means?
While we wait for that.
It's substance use disorder.
Ah,
Ooh, that's a tricky one. Elizabeth, this is definitely your forte. You want to take that one?
yeah, that's a really tough one. Um, I would say in Washington State that, we're rigid moralists, and the idea that somebody is saying that, yeah, you need to accommodate me because I have a substance use disorder, that's going to be a really hard sell to a judge. So I would never make that argument. I would be inclined to make an argument that sounded more like, I'm going to recovery, and then follow through with that could be a reasonable argument. But a Washington court is not going to encourage people to act out because they're, using fentanyl or something. Yeah, no.
Yeah, and I think maybe if there's an underlying issue that's leading to substance use, you could potentially lean on that.
Right? You might
Substance
be
use
able to
is
go
also
there. Yeah. So, okay, the next question is, what can a tenant do when they complain to the landlord with no effect? Well, okay, what the tenant needs to do is lay down their tracks. And I mean by writing to the landlord, dear landlord, the people who live above me were playing tennis at 3 o'clock in the morning. I can't live like this, make it stop. And so that's what the landlord needs to know. In Washington, you wait 10 days, see whether or not it continues. And if it does, you say, that's it, I'm done, I'm leaving, goodbye, and you leave. And so having the funding to do that can be exciting, but I have managed to successfully relocate a lot of people when there was something disturbing their quiet enjoyment. Quiet enjoyment is the idea that everybody has the right to quietly enjoy where they live. They don't get to make a disturbance or a ruckus. They just get to be there quietly. And so if that's not possible, yeah, they can get out. And so, or my other personal favorite one is when people sign up for a rental agreement that says, this is a non-smoking building, nobody's going to smoke here, nothing, we don't care what it is, go off the premises. And then they move in and discover that they are surrounded by people who are, using various substances that they smoke. And that can be very uncomfortable for people. And I have never had a court criticize or penalize a tenant for saying, I signed this agreement. I'm pretty sure everybody else did too. That's not what's happening. I'm leaving, goodbye. And then they go. And so CCS and some of the different organizations in King County can usually rustle up some help with moving expenses. So don't hesitate to ask. Okay,
There was
so
mention of, well, I just want to jump in because there was a tenant on tenant question, and that, I mean,
yeah,
the problem is your options are limited because you can't make the landlord deal with it. Basically, your options are to put up with it or leave, usually.
yeah, that's absolutely right.
It's unfortunate, but that's what the law says.
Yeah. The section in Title 49, it's
So,
4960.
yeah, let me drop a link to an answer to that. It's the specific definition in 49 is 4960.030. That outlines all the protected classes.
Yeah.
What if there's a household containing roommates and each roommate has an ESA? Can the landlord deny applications if they're not pets? So no. Sorry, I should finish the question. Can the landlord deny applications if the pet limit is 2, but each animal is an ESA? Well, they're not pets, so the pet limit doesn't apply. So no, the landlord cannot refuse to rent to people because they have service animals. They're not pets. They do not fall under the pet rent limit, or pardon, pet limit.
Right. The one place that can be a little problematic is when you have a client that has two cats. Well, one of them can be an ESA, two is a little bit more problematic. So I think that it's easier to observe that limit and not push it too far. So what can you do about erroneous fees besides asking the property to remove them? They charge $50 if they're behind with rent and utilities. Okay. It depends on where your client is. Some of the local jurisdictions in
Seattle.
Seattle, Shoreline, Auburn, Tacoma, different places like that have flatly said that a landlord may not charge fees for posting notices. And so landlords, of course, are trying to optimize what they get to charge for, but it comes back to that same idea that a notice fee is not it's not a possessory charge. So
And I would
that's
say, oh, sorry.
no,
This person, really quick too, this person
yeah.
that asked the question is in Pierce County.
Oh,
Oh,
okay. Yeah, so if you're in Tacoma, awesome. I would say check what your local regulations are. And there might be a limit on that. Also, I would say you can argue that the landlord cannot charge that fee if the notice itself is not valid. If they across the board are just refusing to take those off, you're gonna have to wait till the client moves out, and then the landlord will probably take those fees out of the security deposit, and then your client should go to small claims and ask for that money back. And so that's why, documenting the efforts to explain, hey, landlord, this isn't right, here are all the things, and putting that in writing, that can then be used as evidence in small claims of, I tried to tell the landlord, here is me showing them all the reasons why these fees are wrong, and then please give me my money back because a security deposit is the tenant's money. The landlord's just holding on to it. It's not
yeah.
their money, it's the tenant's money.
Okay, I'm looking at a question that says, are these rules applicable to all renters, or are some of these only specific to folks in some recognized or protected category? I would argue that the idea is you don't discriminate against anybody. And so it's not that they have to be a protected category in order to not be discriminated against. It's that landlords are not supposed to discriminate in whatever fashion the landlord thinks is a great idea. So, next question. Have y'all encountered subsidy cases? Housing authority in King County were not excluding exempt income from household rent calculations. Veteran who was a caregiver and through partners and his income was, yeah, that's a really tough one. So the last time I ran into something like this, there was actually a different
And
lawyer's
just, sorry,
office.
I'm so sorry for interrupting. I just want to
Okay,
continue with the question just a little bit because I know that you guys
right.
definitely know what's going on. But and this person they had a veteran who was a caregiver for the partner.
Right,
And they are on Medicaid with
right.
King County. Okay, that's all.
Yeah, it looks like
No,
there were letters about, we can't do this, we can't do that. And then it was only when an attorney got involved that they listened. Yeah, I mean, we see that. And if you're in
all the
King
time.
County, contact us or contact the East Side Legal Assistance Program.
Yep.
Because you might have to fight KCHA. And it's not
There's
fair. But
arguably a person who is a caregiver for somebody else is not the tenant. The tenant is the person with the subsidy who lives there. So they shouldn't be counting both parties as having income. They should just be dealing with the person who has the disability. And that can be really hard for them to understand. So, but it's true. So, anyway, and that does not turn on the lease. That turns on fair housing laws and not discriminating against people with disabilities. And it sounds to me like what that housing authority is doing is trying to say that both of the tenants have their own separate income and that therefore they can approach the subsidy from the standpoint of double income. No.
yeah.
So, yeah.
Will
Anyway,
will the upcoming service animal webinar be beneficial to service providers who reside outside of Washington State? I think so. We're going to definitely cover some federal law in it. We, as Washington lawyers, can answer questions about Washington. It is bad if we try to answer questions about jurisdictions that we are not licensed to practice in. So that's why
right.
a lot of the stuff that the info we can provide that's more specific to local stuff is going to be Washington based, but there's a lot of federal law associated with that stuff too.
Yeah, we get to do federal.
You want me to read it?
Sure.
What about a tenant who has made many complaints to a landlord without any response, such as a tenant that has roaches and mice all over the apartment? The tenant's made many attempts to contact the landlord by mail and text message, but the landlord is not helping the situation. Specifically, when the tenant is paying rent on time, has an elderly mother living in the apartment, and a child that is 8 years old, what would be the best option to help a tenant in this type of situation? Well, this is a little bit, yeah, I think we're veering a little bit off the topic, but well, you love talking about code
Yeah,
enforcement.
I do. Okay, so
Elizabeth is our resident nerd, but we love her for it.
I'm the habitability nerd. Okay, so one of the landlord's absolute duties in Washington State is to control infestations in multifamily properties at all times. And a landlord frequently will say, well, that means I can charge a fee. No, actually, they can't. They don't get to delegate that. And so, if the tenant is careful to put those complaints in writing and make sure that they have a record of that, then the next thing they do is to reach out to whoever is code enforcement for where they live. And that entity can come take a look and they can fine a landlord. They can tell the landlord to correct it. And if the landlord, once they have notice that whoever code enforcement actually cares about it, then they can be required to pay relocation, which is
Yeah.
3 months rent, prepaid rent, their deposits in cash or certified funds within 7 days. So I have no patience for landlords who let things get out of control like that. My only concern is it has been my experience that a lot of jurisdictions do not have the bandwidth to deal with infestations typically. But the one you're describing sounds really gross. So that might totally be worth it to walk into code enforcement and say, I told him this time, this time, this time, nothing is happening. And then if code enforcement says, well, we can't help you, then the tenant can write to the landlord and say, this is disgusting, I'm leaving, goodbye, and leave. Nobody should be living like that.
They've
And
given notice that there's an issue, appropriate time periods passed for repairs to be started, and if they don't start, then the law says, okay, you can bail. I've done it.
yep,
And also just to note, you cannot withhold rent in Washington State, even if the unit
know
is disgusting. I do run into folks who do that, and that will get the client in a sticky situation, especially if they don't hold on to the money. If they think they should be compensated for the diminished value of the unit due to its condition, I would encourage them to go to small claims and
After they move out.
yeah, and say, under RCW 59-18-110, you can say that my unit isn't worth what I paid for it, and the landlord needs to give me some of my money back.
Yeah. And that's perfectly okay. And judges are happy to do that on sufficient proof.
Yeah.
Proof is pictures, not video. Oh my God, don't take video, pictures. So,
It's hard for the court to deal with pictures.
well,
This
it's
brought
hard.
up this brought up a lot of questions and comments talking about bugs and landlords and property. I'm going to drop down really quick.
Okay.
Says, can a landlord charge pest fees if it is tenant caused? So if the bugs infestation is tenant caused, example, tenant brought in bed bugs.
If they can prove that the tenant caused it, but they
That's
can't charge the current tenant for it, they can charge the ex-tenant.
Sure, but proving who brought the bed bugs is basically impossible
Especially
to
with how bed bugs
by
work.
scientific standard that a court's going to believe. So because they travel between units, they aren't stuck in one unit. They're going to go right through the wall and go to somebody else's unit. I have seen rental agreements that try to say, you promise that you haven't brought any bed bugs into this place, and you're guaranteeing that that'll never happen. And under Washington law, I don't think that's enforceable. I mean, people can make their best faith effort and something can happen. And then, nobody knows anything for a year, 18 months, and that tenant moves out, next person's there. Is that the new tenant's fault? No, of course not. So I think that encourages landlords to try to do things that I don't think the law lets them do. So I'm looking at can the landlord evict the hoarding tenant due to safety concerns?
Maybe.
Entirely
Depends.
possible.
Yeah. If they
That-
refuse to clean it up and it's not safe, there's no ingress, there's no egress, or there are issues with, where stuff is located by the heaters, it's a possibility.
Oh, yeah. So,
The partial rent question. Oh, we get this a lot.
love this one.
If a landlord accepts partial rent after a non-payment eviction notice, can they proceed with the unlawful detainer? Yes. So, partial payments. If a client is behind on rent, they can pay whatever they can, and the landlord has to take that money because it's called mitigating your damages. And landlords have an obligation to mitigate their damages. So if somebody is stealing money from them and they don't, walk away from the person who's just reaching into their pocket over and over, then they're failing to mitigate their damages. Similarly here, they've got all these losses that they're saying they've got, but they're refusing to do anything to decrease the loss by accepting partial payments. The reason they do this is I think that they always get it mixed up with complier vacates. If there is a complier vacate issued for a non-continuous violation of the lease, so like you do one thing wrong and then you take money from the tenant, you could potentially waive your ability to evict the tenant based on that single incident. If it's continuing, there's an argument that maybe they haven't waived it, but that doesn't apply to non-payment because at the end of the day, you're asking for money, they're trying to give you money, and landlords, they always say we don't take partial payments. It's not a partial payment, it's a payment towards the amount owed. And the law says any payment that the tenant makes must first be applied to that current month's rent before it can be applied to anything else, before it goes towards back rent, before it goes toward late fees, before it goes towards anything else, it goes towards that current month rent.
Yeah. And that's new. It used to be that the landlord could rack up a bunch of fees and then take the tenant's rent, pay the fees that they were assessing, and then say, but your rent is short.
And
And
start
the
making all over
legislature,
again.
close that particular loophole. I think what's going on is this. I think that the landlord's bar has got their clients terrified that if they accept one dime after issuing a notice, that they won't be able to proceed. And I personally think that's not true because the case law holds that if a tenant owes any amount of rent, then the landlord can proceed with an eviction. And so,
If the non-payment is ongoing, the amount is still
right,
owed. That doesn't go away. And since it
right,
doesn't go away, they can still proceed on it.
right. So, and the 10 days after a complaint and you can move, that's Washington state specific. It's RCW 5918-070 is making the complaint and then following up with 090 that shifts the ability to terminate the tenancy from the landlord to the tenant. And so, yeah, that's state.
If the tenant goes to inpatient treatment for a month, can they lose their subsidy or tenancy? I think that would depend on the nature of the subsidy or tenancy. I know that sometimes, for example, I think it's the HAP contract says, you have to be in the unit so many days per month. And you might need to make, some sort of reasonable accommodation request if they've got this behavioral health issue, it's led to substance abuse issues, and they need to go get this treatment to make sure that they are okay. Then I think that that would be workable. I think that's pretty fact specific. So I would say it depends on the nature of the subsidy and what the program paperwork says. What do you think,
Yeah.
Elizabeth?
Well, I think as long as the rent is continuing to be paid, that the landlord doesn't really have a right to know the tenant's whereabouts. And in a case like that, a case manager could absolutely write a note to the landlord and say, "Dear landlord, my client's going to be gone from date to date. He'll be back. Here's the rent, XOXO tenant." And that should be the end of it. So, and then you'll see these ridiculous notices that somebody cooked up maybe 15 years ago. It says notice of presumed abandonment. And that doesn't actually exist. A landlord can give a notice that says, "I want to go inspect your apartment." 48 hours, they get to go in. It's different in different states. But the idea that they're giving the tenant notice and an opportunity to be there or to say, "No, I can't be there," but they can go in. So a nice chirpy little note from the tenant that says, "As my case manager told you, I'm in recovery right now. I'll be back on date. XOXO tenant." That should be the end of it. That's
I'm not
not,
abandoning the unit, yeah.
yeah. So,
And just to let people know too, we are going to have Elizabeth and Casey back with reasonable accommodations and modifications. So I don't have that date in front of me. I'm so sorry, but we are going to
coming
have
up.
that webinar where there's going to be plenty more information. So
Yeah,
The,
this is
yeah,
your last chance to ask us questions.
yeah,
Oh, sorry.
the thing about the option to leave, does that mean without penalty? Yes. And the reason there's no penalty associated with it is that the tenant hasn't broken the lease. The landlord broke the lease, and a party cannot break an agreement and then benefit from it. That's not how this works. So if the landlord is allowing, people to smoke all over the building, having promised the tenants that that would not happen, the landlord is in violation, not the tenant. And so you wait to see if they correct it and then you go. That is not a basis for a lease break fee. So, yeah, no. Okay, so I'm looking at Steven's question.
Oh, we have one substance use disorders covered under federal housing section 8, correct? No, not really. Like I would say similar to what we said before is it's going to not, you probably can't get a reasonable accommodation based on the substance use alone. If there's an underlying condition that leads to the substance use, then you've got a stronger argument.
Yeah.
But I mean, if there are substance use issues, you can say, okay, they're going to rehab and this isn't going to be a problem again. It just wouldn't necessarily be a reasonable accommodation or disability discrimination issue. Oh, Homestead Act question. Oof, it's been a minute since I've read that. It's a little bit outside of what we do.
Yeah. I think that Northwest Justice
We do.
has been handling vehicle impound questions. And so that might be a place to go, and never take legal advice from the tow company operator.
Or the cops.
All they're going to tell you is what they think is going to get them out of trouble. So, yeah, we'll drop that 5,000 if you'll give us a disposal fee. Oh my God. Okay. I would
And
strongly,
he's also working on an encampment guide, at last I heard, because I'm on that one subcommittee. So I know that they're working on that, should be coming out soon.
yeah. And if this isn't Snohomish, I would absolutely start by getting a hold of Snohomish County Volunteer Legal Services. I think will get you to Northwest Justice. I could be wrong, but this is a question for them because they're working on this right now. So, yeah, I would encourage you to get back to them as quickly as you can.
Can you also repeat who's working on the encampment guide? You cut out there for a minute.
Sorry, the Northwest Justice Project. They've got some attorneys over there who are working on it. I know that they've just finished a draft, an updated draft. I'm not sure when they're releasing it, but at the very least, you can contact the Northwest Justice Project and see what information they currently have available.
Yeah. And Northwest Justice Project is basically tasked with creating the WashingtonLawHelp.org document, and they may very well have it written out in there. I don't know. I haven't looked for that specific question,
They might
but
have one like that they're updating now and it's already on the website. They'll
yeah,
release the new version later, maybe.
right,
Also, I'm seeing some repair questions, just as a heads up. So we actually do presentations with Solid Ground that are tenants' rights presentations. So if you want to send your clients to those, you're more than welcome. I can email the link to Amy so that she can include that in a follow-up email. But it covers all sorts of topics. So repairs, finding a unit, what to do during your tenancy, domestic violence issues, security deposit issues. So we do those twice a month with Solid Ground, and we also do once a month in Spanish. We also do a variety of topics in Spanish.
right. So if the
And
maintenance
your
is
service providers are also allowed to attend. It's not just tenants.
absolutely, come join us. I know what you mean when you say a Band-Aid as opposed to actually fixing something.
Read the
And
question out loud so folks know. What if maintenance is addressed, but it's unsatisfactory, like continuing to fix the problem, quote, but it's just a Band-Aid.
okay, same problem. Make sure that you've documented in writing what the problem is. And then if it's not fixed, take it to code enforcement in that jurisdiction and ask them to come take a look at it. So, can landlords charge a fee for property liability? It's another damn fee, really. Yeah, I don't. Landlords can charge whatever they think they can get away with.
There are no limits on what fees they can charge, unfortunately. If you know, one thing that, unfortunately, the rent stabilization bill did not pass this year. But moving forward, I would encourage folks to connect with the Washington Low Income Housing Alliance. If you're interested in that, because rent is technically a recurring monthly charge, and the rent stabilization bill would help curb a lot of the charges and fees and monthly everything that are upped basically every year for tenants. So I
Right.
I'm ready. I need to start writing down what I'm sending.
Yeah, property liability fee is actually kind of creative. No, that's what insurance
Are.
is. So, yeah, no. Um, but a landlord can claim any kind of fee as long as they make it absolutely clear in their rental agreement that it's a fee and it's not going to be returned under any circumstances. And that is what's different from a deposit, which the tenant can recover if certain conditions are met. So anything they want to call a fee, they can do that. And so the way to approach a landlord like that is to say, well, guess I'm not going to live here. So the other thing we're seeing is valet trash service, where it's like the medieval days where you put your trash outside your door and they would come around and pick it up at some random time. Oh my God, that creates such a mess. So there's a couple of people trying really hard to make landlords stop that because
Yeah.
it does not solve the problem. Okay,
And
do
I think
landlords know
actually that's
about
sort of
this?
related to the next, well, yeah, sorry, Elizabeth, please. But I think
Okay,
kind of related because, can they charge these fees? Landlords can charge almost anything. And are they, okay, sorry. So do landlords know about these laws? I see notice and pest fees often. It's really important to understand that a landlord is a business owner, and the entire purpose of a business is to generate profit. So they are going to charge whatever they can. And if they can get away with it, then they can get away with it. And they might know and still be trying to get away with it, or they might not know. And they are not really fulfilling their obligation as a business owner to fully understand the regulations that govern their business. Like I said, there are a ton of resources online. There are a ton of landlord agencies and organizations too that they can join that provide lots of trainings. So at the end of the day, though, it is their obligation to know. And if they don't, then that's on them and that's their problem.
Okay, so
Good landlords that do the work. I do want to note that. So it is possible.
when you see fees, do we tell the tenant to contact Northwest Justice Project, or can we tell the landlord they can't charge them? You can always tell the landlord, but you can't tell them much. And
Yeah.
so, what I think would be more efficient would be to find a different place to live if it's bad enough, and if the client can leave without any kind of penalty. But
Okay.
once the client leaves, then consider going after that landlord in small claims court to recover that money. So, but different jurisdictions have different ideas about fees and what's allowed and what isn't. So that's a really tough question to answer as a blanket answer. It's just, it's all different everywhere in the state.
Oh, excellent. Thank you, Amy. Or Peyton, sorry, I'm just seeing now the chat. I was looking at the questions.
Oh, what?
And Peyton was kind enough to post all of our future presentations in the chat. Amy was also wonderful and posted the info for Washington Low-Income Housing Loans. Peyton got the Northwest Justice Project covered. So there are links in the chat for those who can see it.
Right. Oh, if you have a lead issue, somebody's saying we had an issue like that with lead. That goes to the Puget Sound Clean Air Agency. And if it's in Eastern Washington or elsewhere, could be the EPA. But at least in Washington, they have no patience for lead issues. So yeah, I'm sorry, I just read that.
All right. I'm trying to go through. Okay, so if you have any questions, I'm just going through the chat because I was this whole time and now I'm like, oh, there's a lot of stuff in here.
I think we got most questions from the chat into the Q&A, which is perfect. Thank you everybody so much for doing that. We can't copy and paste, and we would like to, answer those questions and let your voice be heard. So thank you for putting them in the Q&A. This was so informative. You both are wealth of information, and I am so excited to have you back 3 more times discussing different topics related to tenant law. It's going to be so great. So thank you. As I'm talking here, I'm trying to share my screen again, so I apologize.
And thank you to all of you for attending. We really appreciate it. And really appreciate your investment in your clients and the work that you do, that you are, digging in and trying to learn more. And we're happy to be a resource for you. So thank you for all that you do.
Yeah,
and attending.
And again, your feedback is important. So please do fill out the survey and
review it. And it impacts how we do our presentations. So if you want to see something different, let us know.
Absolutely. Thank you so much. Like Casey and Elizabeth said, thank you so much for being here. We appreciate it.